On October 12, 2011, the United States Supreme Court will hear the case of Burlington County, New Jersey businessman Albert W. Florence, who in 2005 spent 6 days in county jails and was twice subjected to whole-body strip searches for a non-criminal offense. Lower federal courts are divided on how to interpret a previous Supreme Court ruling, giving correctional officers some authority to strip inmates for searches in local jails. The court will now address the question of whether the Fourth Amendment, which prohibits unreasonable searches, permits the state to conduct suspicionless strip searches of every individual arrested for any minor offense, no matter what the circumstances. Here's Mr. Florence on his case.
That day, it was a very happy day. It started out to be a very happy day. The weather was nice. My wife and I and my 4-year-old, we just went to go complete a purchase on a new home that we were building, and everything was all smiles and laughter. And my wife was driving, and I was a passenger, and my child was in the back. My wife was followed off of the 295 expressway by a state trooper. So as he's following us for about a mile or two, I said to my wife, I said, "Are you speeding?" She says, "No, of course not. I'm doing normal flow of traffic. I'm not speeding." The driver comes to my wife's side and asks for the registration and insurance and driver's license for the vehicle. The trooper goes back to his trooper car, and not even a minute later, he comes up to my side of the door and says, "Well, who's this vehicle belong to?" And my wife says, "It belongs to my husband, Albert." I said, "I'm Albert." And the trooper asked me for my driver's license, and I gave it to him. He said, "Sir, you're under arrest." I'm like, "Wow, okay, for what?" He says, "Well, there's a warrant out for your arrest." I was told to place my hands behind my back. I was told to spread my legs, and I was arrested right there in front of my pregnant wife and my 4-year-old son. He never gave us any indication as to why we were stopped, and to this day, there was no reason. Now, before I was taken to prison, I'm actually in the county facility at that point. I was ordered to take a shower with this disgusting smelling soap and bathe, which I did. But before I was told to put the jumpsuit on, I had an officer stand about arm's length with a curtain open, and he instructed me to lift both hands up, turn around, squat, manipulate my genitals, stick my tongue out, cough. Even thinking about it, even speaking about it, still brings me, chills. I decided to sue because I felt like I was wronged. I felt like my rights were violated. I felt belittled. I just felt that I needed some type of justification.
Albert really didn't have a choice not to sue in this situation.
That's Susan Chana Lask, appointed class action attorney for this case.
He wasn't even an inmate when he was taken in. He was just an arrestee for a non-criminal offense. Fortunately, we got that great decision from Judge Rodriguez in the district court. We were proud of that. And then the Third Circuit kind of backed up and said, "Hey, look, we don't want to get involved. We're just judges. We're not jailers." But the judicial system owes us a duty. They owe us a duty to enforce the Constitution. That's what we're looking for.
The Supreme Court has not specifically decided on the issue of strip searches since 1979 in a case called Bell versus Wolfish.
That's Angela Davis, professor of law at American University's Washington College of Law and expert in criminal law and procedure.
The court held that a correctional facility may conduct a strip search, including visually inspecting body cavities of inmates who choose to engage in planned contact visits with outside visitors. That situation, of course, is very different from the situation of Mr. Florence. He and his lawyers are not saying that prison officials should not have the right to search, even strip search individuals who come into a facility. Smuggling is a problem. What they're saying is that there must be a reason. The question that courts grapple with and that law professors and people who teach the Fourth Amendment grapple with all the time is, how do we balance the right of the individual to be free from unreasonable searches and seizures as they are guaranteed by the Fourth Amendment on the one hand, versus our need for safety and security, our need for prison officials to keep facilities safe and secure. The Roberts Court, when it comes at least to regular criminal cases, has been more friendly to police than they have to individuals in Fourth Amendment cases. Of course, here we're not talking about police officers, we're talking about correctional facilities, but it's still a Fourth Amendment case involving the government's rights versus that of the individual.
I'm actually smiling, even when you say the word Supreme Court, because that's the highest court in the land. Growing up, that's what I studied. I knew about the 9 justices. I know what their responsibilities are. Even with this case, I know more about the Constitution and the amendments of the Constitution, and I'm excited. I'm thrilled to go before the 9 justices, and just even have them say my name is surreal.
It is surreal, and it's an amazing journey that we both had together to get to the Supreme Court and get an answer on this issue.
The Constitution speaks for itself, and we'll see.
This has been a program of the American Constitution Society and the National Constitution Center. For more information, visit acslaw.org and constitutioncenter.org.